Buckle up, folks, because this case is one you don't want to miss. We've got Juliet von Oceanbear Martinez, a defendant who's already no stranger to the courts, facing a misdemeanor charge for drug paraphernalia possession. Now, at first glance, you might think this is just another routine arraignment, but what makes this moment so gripping is how unprepared Martinez seems to be. From questioning whether she really needs an attorney, to asking if the whole case can just be forgotten. Her responses give us a raw look at someone navigating the justice system without a clear strategy. That's dangerous territory, because in a courtroom, every word matters, and every decision could change your future. The stakes here aren't just about fines or jail time. It's about whether Martinez understands the system well enough to protect herself. And trust me, things only get more intense as the judge starts pressing her on probation, other pending cases, and how this charge could stack up against her record. Stay tuned, because what unfolds shows exactly why having legal representation can make or break a case in ways most people never see coming.
Court does call the case of the people versus Juliet von Oceanbear Martinez.
Clarence on behalf of Judicial Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand that?
Right.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't necessary.
Is it necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Miss Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court on any other things?
I am, but none of them are drug related, and they're about to be finished.
Well, maybe. What other courts are you before, Miss Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like, have it like
To do what?
have it go, like, is there any way to like forget about this somehow? Is there anything that I can do, like community service or something that I could do instead of
Ms. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, me knowing a little bit about your history, I don't know that would be a wise.
Here's where things start heating up. Notice how the judge, after hearing Martinez, insists she doesn't need a lawyer, quickly shuts that down. Why? Because the judge knows Martinez is at risk of incriminating herself. Think about it, she almost blurted out a guilty plea without realizing the consequences. That's huge. In criminal court, Even a misdemeanor charge can carry jail time, fines, and probation conditions that follow you for years. Martinez asking if she can just do community service instead shows she's trying to negotiate with the court directly, but that's not how it works. The system doesn't bend to wishful thinking, it follows procedure. This moment highlights the power imbalance between defendants who don't understand the law and the legal professionals who do. So here's my question to you. If you were in her shoes, would you risk representing yourself to save money? Or would you let a public defender take control, even if it means less freedom over how your case is handled?
Call on your part.
Guess so. Like what? Like, I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like, I can have this be adjourned with a bond. Can I know what the bond is?
Mr. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So,
I'm not protesting to the allegations. I would like to just.
Well, hold on. I don't want you saying anything about the offense.
Well, I do. I see no way around it. It's plain and clear and simple.
Well, I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
But it's clear. It's plain. Like, really.
Well, I don't know that, Ms. Martinez.
Yeah, I guess I'll go with a lawyer. Sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez. Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
Should have left with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000. 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor.
And that wraps it up. Martinez ultimately agrees to representation from the public defender's office, which might have saved her from a huge mistake. The judge sets a bond at $5,000 with standard conditions: no alcohol, no recreational marijuana, and no illegal drugs, while acknowledging her other pending cases and a scheduled forensic evaluation. This outcome shows us the careful balancing act courts perform, protecting the community while also ensuring the defendant has fair representation and access to services like forensic assessments. Whether you see Martinez as reckless, overwhelmed, or simply unprepared, this case is a textbook example of why arraignments can be deceptively dramatic. So, what do you think? Was the judge being protective by insisting on counsel, or too harsh in pushing back? Drop your thoughts in the comments below. And if you found this courtroom breakdown as shocking as we did, make sure to hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom moments every week.
Thank you, Ms. Martinez. Well,
Miss
I'll be
Ma'am, it says the forensic center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez, but you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate.